Hi, good afternoon, everyone. Thank you for joining us. My name is Mariana Manzacook. I am Director of Business Retention and Expansion for the Woodlands Area EDP. We have today our third and final in a series that we've been doing, HR Forum. I'd like to thank you for taking time out of your busy day to join us. Today's webinar will be recorded and we will be sharing it as a resource for all of our major employer contacts. So we have chosen to present this in a webinar format so that you can feel comfortable. So please ask your questions. You'll note there's a Q&A box there at the bottom, and we do welcome those. And you can submit a question anonymously. So please participate. And of course, if you come up with any questions afterwards, we can pass those along as well. So I'd like to begin by introducing our moderator for the session, Ms. Holly Gruey. Holly has been with the Woodlands Area EDP since 1999. She serves as our Chief Operating Officer. In this position, she's responsible for day-to-day operations of the organization, which includes managing the organization's staff, our budget, accounting processes, and functions. She also serves as our HR Administrator, which is why I've asked her to participate in this forum today. Thank you, Holly.
Thank you, and hello, everyone. As Mariana said, I'm Holly Gruey, the Chief Operating Officer for the Woodlands Area EDP. I want to thank you, send a thank you to our presenter, April Walter, for covering today's forum topic. The rules are changing, important employment policy considerations you should know. April is Senior Counsel at one of our valued partner organizations, Kean Miller. She specializes in the practice of labor and employment law issues, and we appreciate the presentation she's put together to share with us today. And with that, I'll pass the mic over to April.
Thank you, Holly. Good afternoon. Thank you for joining us today. I'm going to be covering four main topics in our hour. The first is the expansion of Texas sexual harassment law that just took effect this past September 1. Second big topic is President Biden's executive order on non-competes that was issued this past summer on July 9th. Third issue we'll be covering is poster compliance for remote workers, those posters that we usually see in our break rooms or near our time clocks. What do we do when we've got workers working from home? And finally, some just best practices for employee handbooks. And an overarching theme for all of these four topics is to try to give HR managers and business owners tips on best practices for the paperwork. We can't control what our employees do. We can't control human behavior, but we can control our paperwork. And an ounce of prevention is worth a pound of cure. And so I'm hoping that everybody leaves this presentation and they've found at least one, if not a couple of tips that they think, we've got to tighten up our paperwork. Because the better your paperwork, you're going to simultaneously reduce the chances of somebody engaging in some misconduct that exposes your organization to some liability. And you're also going to simultaneously increase the strength of your defense in the event that you do get sued. So let's shift to our first topic, the 4 expansions of sexual harassment law in Texas. So we're talking about the Texas state statute, not the federal counterpart, which is Title 7 of the 1964 Civil Rights Act. These amendments just took effect September 1, 2021. Because these are such recent amendments to the statute, unfortunately, we don't have any cases because it's going to take some time for cases to be litigated under these amendments to the statute. We're going to have to see the behavior happen, the claimant bring the EEOC charge or Texas Workforce Commission charge, it make its way through the trial court system, make itself up into the Court of Appeal or even to the Supreme Court level before we start seeing cases interpreting these amendments. And so right now, all we have is the statutory text to look at and can make educated guesses or speculation on what it all means. We're talking about amendments to Chapter 21 of the Texas Labor Code. That's commonly referred to as the Texas Commission on Human Rights Act, or TCRA, and it outlaws a lot of forms of discrimination and harassment. But these particular amendments are applicable only to sexual harassment. So this is something that's happened in the wake of the Me Too movement. It's something that the Texas legislature picked up on this last session, and Governor Abbott signed into law to enhance or beef up the state laws against sexual harassment, but it's not applicable to the other types of unlawful discrimination or harassment that are covered by TICRA. So how has the law changed? There are 4 big expansions to the laws against sexual harassment in the workplace that these amendments have implemented. The first is now the statute covers any employer who employs only 1 or more employees. The law used to be that you had to have at least 15 employees to be covered by these laws. But now you have 1 or more employee and you could be sued for sexual harassment under this statute. A lot of smaller employers, and I understand that our audience is more larger employers, so I don't think this is as big of concern for the audience here, but with a lot of smaller employers, they would even wait to adopt a handbook until they had at least 15 employees, which is, I don't think that's the best advice. I think even before this change, if you were a small employer, it made sense to have a handbook. But now, certainly with this change, every small employer with 1 or more employees should have either a handbook or at least a standalone policy against harassment with complaint mechanism and policies against retaliation for bringing those complaints forward. The second big way the statute has been amended is that it redefined the term employer. And in redefining the term employer, it arguably suggests that there might be some grounds for individual liability where owners of businesses or managers of businesses could be named as defendants to these types of claims, because the definition of employer has been expanded to any person who acts directly or in the interest of an employer in relation to an employee. And because of this threat of potential individual liability, I think now is a great time to roll out some additional training for your management personnel, your line supervisors, who are the most likely to observe instances of sexual harassment or have it reported to them. The third big change was it arguably heightened the standard for an employer's response once they have observed some instances of sexual harassment or a complaint has been brought forward. Under decades of law, the standard used to be that the employer was supposed to take a prompt remedial action when they received a complaint for sexual harassment. Now the statutory language has been changed to immediate and appropriate corrective action. And it remains to be seen, is immediate something faster than prompt, or are they essentially equivalents under the law? We don't know yet. Again, we're going to have to wait to see those courts, how they deal with this amendment. But the thinking is, if the legislature bothered to change the language, they probably intended it to mean something different than the status quo beforehand, which was requiring a prompt remedial action to be taken when there's been any complaints or observations of sexually harassing behavior. The fourth big way that the law has been expanded is that the deadline for a claimant to file a charge of discrimination with the EEOC or the Texas Workforce Commission has been lengthened. Now, instead of 180 days after the harassing conduct, the claimant has 300 days after the alleged conduct to exhaust their administrative remedies, go file that EEOC or TWC charge, which is, of course, the first step before filing any lawsuit. So now that, and I should mention too that the language itself, the statutory language, it's literally less than, it's a page. If you printed out the enrolled bill, it's with even the signatures of the speaker and the president of the Senate, it's less than a page long that we're dealing with in terms of amendments to the statutory text. So not a lot of wordy, lengthy amendments, but amendments that have significantly shifted the law here in Texas. So what are the big takeaways for employers in handling these changes? First, if you don't have a sexual harassment policy, by all means, you need to adopt one now. And then even if you have one, it's a good time to update or audit your policy, making sure that it's a well-worded one, that you've got, for example, more than one recipient to hear complaints. And certainly like if in smaller or family-owned businesses or closely held corporations, you're going to want to make sure that one or more of those recipients of the complaint is someone who can be viewed as more of a neutral party to by the workforce. Otherwise, sometimes plaintiffs will complain, well, of course I didn't complain because I didn't want to complain to the owner's wife. She was in charge of HR, and that would be my complaint would go nowhere, so I didn't bother to complain. So now is a good time to kind of review our sexual harassment policies and make sure that they are in the best shape that they can be. Another thing is now is a good time to remind our workforce about those existing or audited policies. And when I talk about best practices regarding employee handbooks more generally, I'm going to talk about some tips on how we can utilize our employee handbook, make it a resource and tool for us that really helps us in our personnel documentation and helps us build some evidence in the event that we are sued. And so now is a good time to just roll out a reminder to our workforce of our policies against sexual harassment. As I mentioned a couple slides ago, it's also a good time to train our managers, especially since they may face potential personal liability, about how to respond to complaints or personal observations of sexual harassing behavior. We certainly want to make as immediate, or prompt and quick of a response as we can when we do receive complaints of sexual harassment or observe sexual harassment. And finally, I want to mention that here at Kean Miller, we operate a couple of different legal blogs. We have one that's Texas specific. And so if you were to just Google Kean Miller Texas legal blog, you're going to find our legal blog, and it's got a stream of articles. We tend to publish like once every couple of weeks. And I've written a lot of articles on employment law matters. And in there, I wrote on July 20th, a brief article about this topic. In there, you will also see a link to that enrolled bill. So if you wanted to read the statutory language yourself, if you found our blog and then linked through, you would get a copy of the actual statutory language that has been changed. So now I'm going to shift gears to President Biden's July 9th, 2021 executive order regarding non-competes. The name of the executive order was the Executive Order on Promoting Competition in the American Economy. So a very broad topic in terms of what the title was cluing us into what was going to be covered. And in fact, it was a very broad brush executive order, so much so that the White House issued what they called a fact sheet to kind of distill what the executive order was saying. And in this kind of summary or recap of the executive order, the White House wrote that this executive order included 72 initiatives by more than a dozen different federal agencies. So again, this executive order just didn't cover non-competes. It covered a myriad of topics. And the main thrust of all of these topics was a desire by this administration to avoid the consolidation of power into some big corporations. And so it talked about, for example, consolidation of power by airlines, because you could think there's only a few airlines that we have in our country here. And so there can be a consolidation of power, like a monopoly-like type power if you have very limited people in the industry. But it also went on to talk about things like chicken farmers. So all kinds of different, it was a very wide array of topics that were covered in here. But in the executive order, there was some commentary about non-competes. And a non-compete is those contract clauses in employment agreements that says once an employee is separated from this company, you're not allowed to go compete against us. And usually it'll say, 6 months, a year, 18 months, 2 years, what have you, after you've left, you can't compete against us in this particular marketplace. And previously, this has always been a matter of state law, and the states vary widely in what is allowed in terms of non-competes. So I'm, for example, from California, and the first 10 years I practiced in law was in California. Non-competes are illegal in California. You can't require an employee to sign one. But here in Texas, on the opposite end of the spectrum, non-competes are allowed. And they're allowed so long as they are seen as reasonable in terms of the substantive scope, like what sort of activities is the departed employee prohibited from engaging in, so long as they're reasonable in terms of the geographical scope, like what is this just in the greater Houston area? Is this in the entire state of Texas? Is this in the United States? Is this international? What is reasonable relative to what this employee did when they were working for the employer that required the non-compete? And finally, they need to be reasonable in terms of time length. So courts tend to say anything under 2 years tends to pass the smell test, it seems like, under Texas case law. Well, this has always been the province of state law. And here we have President Biden saying he wants the chair of, and I'm going to quote from the language because the language I think is significant. He wants the chair of the FTC, which the FTC is the Federal Trade Commission. He says he wants that chair of the FTC to be encouraged to consider working with the rest of the commission to curtail the unfair use of non-compete clauses and other clauses or agreements that may unfairly limit worker mobility. So the bottom line is the law has not changed. That is not a new law. That is not, thou shalt going forward have this rule. That is not, here's the new national standard that preempts and replaces any of these myriad of state law standards. This is just a directive from our president to the chair of the FTC that the FTC chair be encouraged to consider whether he might do something to change the law. But as of now, there is no change of the law. And you wouldn't really know that if you were paying attention to the headlines in the middle of this summer, because the headlines were all over the place, acting as if there was now a ban, a national ban on non-competes. And the fact remains, there has not been a national ban on non-compete agreements. Instead, there has been the president saying he'd like to encourage this FTC chair to look into whether or not there should be ways to limit their use. And so some people say, well, what does that mean? There's been talk of maybe you only allow non-competes if somebody's making over $100,000 a year, or only you allow non-competes in certain industries or certain executive level positions or sales positions. So there's been talk of, well, what does he want the FTC to consider? A whole host of ideas that could be considered. And then ultimately, if there was the FTC or some other agency were to act and implement some rules, there would of course be legal challenges to those new rules in the court, particularly since this has typically been the province, the exclusive province of state law. This has not been a matter where the feds have tended to regulate in the past. And so if the feds were to come in and regulate short of any kind of act of Congress, it would probably see some significant legal challenges in various states like Texas that is pro non-compete. So what are our big takeaways? Non-competes are still enforceable in Texas. Non-solicitation of customer clauses are still enforceable in Texas. Non-solicitation of employee clauses are still enforceable in Texas. And so if you are, as an employer, have some trade secrets you need to protect, or you have some very high important sales folks, executives that you want to kind of make sure that they do not leave and go to head-to-head competition with you when they leave, you can still, at this point in time, if you don't already have one, and I'd recommend that you do so with the help of an experienced employment lawyer, draft up a non-compete. Or if you don't want to do a non-compete, do something less than a non-compete, which is a non-solicitation of customers or non-solicitation of employees provision. I also point you to, I did a blog article on this topic as well. And in that blog article, I had a link to the actual July 9th executive order that covered all kinds of different topics, as well as that fact sheet that the White House issued to help us kind of better understand what it all meant. So now I'm going to shift to the third topic, poster compliance for remote workers. Before the pandemic, if you had asked me, hey, we're shifting people to the workforce to work from home, what do I do about those poster requirements that I have? Because I've got a picture of, those laminated collages of posters that we often see posted in our break rooms or in our near our time clock or some other publicly accessible area of the workplace. What do I do now if I'm going to have somebody work from home? I would have, as a lawyer, speculated, well, you could just email them a copy or hard copy mail them, or give them the next time they're in the office a hard copy, so that that at-home worker has a copy handy. And if at any point in time, 6 months from now, 8 months from now, if they think their rights are being violated with respect to overtime law, let's say, well, they could go find that email or go find that hard copy you sent them. And I would have thought as a lawyer that was a pretty good guess to what might be required. But the federal government has said, no, that's not sufficient. And why have they said that? They've said that several of these statutes that require these various posters for employees, they use language like post and keep posted, or notice, provide notice at all times. So the Department of Labor, which is a U.S. agency, the Wage and Hour Division, which is responsible for, there was only 4 federal statutes that this Field Assistance Bulletin actually covered. One is the Federal Fair Labor Standards Act, which is the minimum wage and overtime statute under federal law, the FMLA, which is the Family Medical Leave Act, the Polygraph Protection Act, and then finally the Service Contract Act, which deals for employers who have federal contracts with the, so they're doing business with the U.S. government. So this DOL WHD Field Assistance Bulletin said, no, emailing a single copy is not good enough. Giving the employees a hard copy of these one time, not good enough. Instead, they, in this bulletin, say you need to post it on an intranet site or post them on some internet website or some other shared network drive, some other electronic system that you have, basically have them on repository. Besides saying we want them to be posted somewhere electronically, the bulletin gave some other benchmarks for what it saw as required for the employer to be in compliance. First thing it said is we want the affected workers to be notified that you've put everything over on this electronic repository or library of your posters. And I think even though they've said that emailing folks a copy isn't sufficient, if I were writing the email notice to tell people where to go find the copies on our system, I would probably attach a copy of them too, just as kind of a belt and suspenders. Like, not only did I tell you where to find them, where we posted them, but I actually did give you a copy as well. And it's interesting to say that California, within the last couple of weeks, recently passed a statute saying that emailing the single copy is sufficient in California for certain California state law notices. So I think other states are going to catch up, and maybe even the federal government, just like with all the COVID related legal guidance that we've gotten out of various agencies. It's been an evolution. It changes constantly. The laws having to kind of make up speed with how our workplaces have evolved, because our new normal is completely different than the way the law was, the way people did business when these laws were passed. And so I think maybe just like California recently passed a statute dealing with some California state law notices, we may see some different guidance out of the federal government besides this field assistance bulletin that I'm talking about, where the federal government might give some different standards for, yeah, you can email a copy, or, you know, this is what we want you to do to make this compliance. And again, why does this matter? Getting our paperwork in check, doing what we can do as HR managers and business managers on the paperwork front. And that way, if somebody sues us, let's say for an overtime class action, and in the context of that overtime class action, when we're defending against that and we're presenting evidence, we would be able to show, well, we put the poster up, and we even gave the poster like we should have, in the manner that we should have, to all the remote workers that we had. So it's just good business practice one, and it's good in the event of a lawsuit to be able to point to the way you had your ducks in a row and you did the paperwork right. The other standard that the field bulletin says, we want this access to be available without having to request permission. So they don't want any kind of like, mother, may I see those notices? Because then the employee is going to feel concerned about even asking where to access them or how to access them. There can't be any like password protection. They just need to be able to like click, 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 and boom, they can see them. So no restricted access to those posters. The affected workers should be able to easily determine which posters are applicable to them. And be mindful too that some of these statutes require posters for applicants, which is interesting because you might need to have some sort of portal where you post online your job postings and stuff, where an applicant, if you were being technically correct, where the applicant could then just click and see some of the posters that are applicable to applicants. And again, I did a blog on this. So if you wanted to read more or click through and read that actual DOL WHD Field Assistance Bulletin that I'm talking about, there is a link on my blog article to that particular bulletin. So now we're going to shift to just some best practices for employee handbooks. In my 25+ year career, I've written a lot of handbooks, I audited a lot of handbooks, and I think that I've dealt with a lot of handbooks in litigation, good and bad. So here are kind of my best tips that I can offer about preparing your handbook and using your handbook. As I've mentioned a few times, it's key evidence. It's going to be discoverable in any kind of lawsuit. And so you're going to want to have your handbook in the best shape it can be. Not only is it great evidence, it does improve your business operations. You're just going to be a better business operation if you have good policies and procedures that have been thought about ahead of time and everybody's being consistently applying them. Of course, you're going to have signed acknowledgments of receipt. And I suggest that there be signed acknowledgments of receipt every time the employee sees the handbook. I can't tell you how many times I get the personnel file in the course of a lawsuit and somebody's been working for a company, 7, 8 years, 10 years, what have you. And there's one acknowledgement of receipt in the personnel file for the one time they acknowledged receipt of the handbook when they were onboarded, when they were hired. And in the meantime, there may have been updated versions of the handbook rolled out, but yet they didn't get the acknowledgement of receipt signed, or at least if they did, it didn't get put into the personnel file. So you want to have those signed acknowledgements of receipts, not only on onboard, but every time you distribute the handbook. And in this day and age, we should be able to electronically distribute the handbook very easily. It's just an electronic copy. There's very minimal cost associated with that. And I would suggest that you redistribute your handbook at least once annually, and pick a time of the year that you're going to do this. Like it's, every year around the New Year's, we're just going to send out a blast, attach our most current version of the handbook, figure out a way where you keep a record of who received that email distribution so that you could even print a copy of that email for everybody's handbook or everyone's personnel file that got it, so that you have a record that, yes, we are utilizing this handbook. We're reminding employees of these policies. Again, require another acknowledgement of receipt if you are going to redistribute. You want to periodically update your handbook too, besides just rolling it out over and over and over again. It should be a living document. The law changes pretty much in some way that affects a handbook every year. Every year I'm having to adjust what I typically consider my standard handbook policy statements because of some change of the law. And so it should be periodically updated. You should also, I recommend maintaining a hard copy somewhere in your business establishment. And this could be, you could print a copy and hang it from a clipboard near all those posters that you have, or print out a copy and put it in a 3-ring binder and put it in the employee blank break room, or put it on a shelf near the time clock. Because now, is anybody going to look at it? Maybe not, but the point is it's there. And that way, if the company gets sued, the HR manager, when they're testifying about what they did to try to prevent, for example, sexual harassment, they could say, not only did we have this robust anti-harassment policy in our handbook, and we distribute it and made people acknowledge receipt of distributions of it, but we kept a hard copy of it handy, just like those posters, where if anybody at any point in time wanted to just walk over and pull it out and flip through it, they can see these policies. And finally, because these are living documents that change over time, it's very important that you have somebody in your operation that is kind of the custodian of records. They are going to archive all of the old out-of-date versions. Because when I get that handbook acknowledgement in the personnel file from 8 years ago or so, I can't tell you how many times the employer then gives me their 2021 version of the handbook. And they say, well, this isn't really good evidence, because all we have proof of is that this gentleman received the 2014 version. So I need to see the 2014 version because we need to put into evidence what we actually gave him. And so it's very important that as you're changing your handbook, you also want to make sure someone is in charge of keeping those archival copies. I advocate ending analysis paralysis. I can't tell you how many times clients will call me and they say, this has been on my to-do list for 3 years. We're going to audit the handbook, we're going to fix it, but I'm just overwhelmed. It seems like a big project. And literally when you get an attorney involved, can be done in a week's turnaround time. Usually it's only usually a couple of $1,000s total from beginning to end for the whole entire process. So I really suggest that end the analysis paralysis and do it. Either create the handbook or update the handbook if you haven't updated it in a while. It doesn't have to be a perfect document. There are so many ways we can word things. And I think the analysis paralysis comes into effect when they've seen different copies, they've seen different versions on the internet, and they think, well, I just don't know if this is the perfect way to word this. Well, it doesn't have to be perfect. You do have to be careful because you don't want to say something that gets you into trouble. And I'm going to mention some things that are said that gets you into trouble. But close enough and well enough grammatically is good enough. You have to worry about some things you don't want to say, but it doesn't have to be, this pristine masterpiece that should be on the New York Times bestseller list. It just has to be well worded enough. And it's always recommended that you have a qualified HR professional or an employment lawyer involved in some of these periodic reviews as well. I also always recommend to translate the handbook if a significant portion of your workforce English is not their first language. It's pretty much worthless paper if you've got, for example, Spanish speakers and you've given them an English handbook and they're not fluent in English. And it's not expensive in this day and age to get the handbook translated into an alternative language. So now I've given my pitch for either adopting your handbook or making sure that it's in the best shape it can be. Now I'm going to give you my pitch for actually using it. Instead of just using it from hey, I gave it to everybody, there are other ways you can use your handbook. And I think it makes your life easier. Anytime you talk to an HR manager or an employment lawyer and you're about ready to make a termination decision, you're going to hear the mantra, did we document? Did we document? What did we document? They're going to want to see documentation in the personnel file of progressive discipline or things that were happening to warn this employee that they were not doing well and that they might be fired. We're also busy that it becomes very difficult to do that. So people just don't do it. They're not very good at their documentation. And one thing I advocate besides using the handbook, use your own email. Email yourself. If you're a supervisor, email yourself something like spoke to so-and-so, they were late to work again, reminded them of our call-in procedure, and then email that email to yourself. Now you've got a date and time stamped record. You print that off and put that in the handbook. So it doesn't always have to be getting out the write-up form, filling out checking all the boxes, making sure you filled it in correctly. It doesn't always have to be that onerous. Now, ideally, you do that. But if you don't want to take that step and you want to just make quick records of discipline or coaching that you're doing, I recommend using your handbook. If you've got a section of your handbook that deals with call-in procedures, for example, and the employee keeps messing up and not calling in correctly when they're going to be late to work, print out 2 copies of that page of your handbook. When the next time you meet with the employee to talk to them about the issue, you say, I'm going to give you a copy of our correct call-in procedures, and you can take that copy home because we're going to want you to follow that going forward. And then I'm going to ask you to also sign this extra copy that I've made because I'm going to put this in your personnel file just as a reminder that we spoke about these rules. And so it's much easier when you don't have to fill in the fancy form. If it's just a matter of print a page, have somebody sign a page, put it in the personnel file. It makes disciplining and coaching documentation a little easier, in my opinion. Also, use your handbook for training. Ideally, you have periodic training sessions on the laws against discrimination and harassment and retaliation. And you have an HR professional or employment lawyer come in, do a lunch and learn, spend an hour, do a fancy PowerPoint, you spend the entire hour talking on that subject. Great, fantastic. But you don't have to necessarily do that. You can do other things throughout the year that document your effort to train your workforce on the laws against harassment, discrimination, and retaliation. For example, a lot of times this time of year, people do their open enrollment meetings for insurance benefits purposes. So you've got everybody convened in the same room because you're going to talk about benefits. Well, why don't you print out the 2 to 3 pages of your handbook that deal with harassment, discrimination, retaliation issues and distribute to everybody, and have somebody take the floor for 5 minutes and just remind the audience of these rules that you have And then put some sort of documentation like a sign-in sheet or something so that you have a record that you gave that training. Now, in a future lawsuit, when the question comes, when did you last train, Joe Harasser on the rules against harassment? You can say October of 2021 when we had this meeting, and it was one of the topics we covered. Another common time to bring up this topic is like in safety meetings, periodic safety meetings they have. So you just print out a couple pages that are pertinent and keep redistributing those in the context of giving training blurbs. And then you always want to be consistent too. One area that there can be inconsistencies is on vacation. Sometimes they'll pay it out on termination, sometimes they won't. And that's a breeding ground for a discrimination claim. So you want to make sure you've looked at your handbook to see what does our policy about payout of vacation upon termination, so that you make sure everybody that gets terminated gets the same rule. So now let's turn to some ingredients in the handbook. The introduction is critical. You wouldn't think it's one of the most important pages. A lot of people might think it's just a bunch of fluff, but I think it's probably the single most important page besides the actual harassment, discrimination, and retaliation page. You want an effective date, either on the footer or header of each page or on the cover, so that you can know the timeline of what version this is. You usually will have some sort of welcome message from a president or CEO. There's always some statement about employment is at will here, meaning that either you can quit or we can fire you at any time with or without advance notice and with or without a good reason or cause. The intro usually says something about this handbook is not a contract. There's no contractual rights that arise out of this document. And it is the employer's sole and absolute discretion to change the handbook at any time it wants, just upon notice to the employees. The rules have changed. We used to pay out for vacation, now we're not. So there's that kind of retention of the discretion to change the rules. There's usually a comment about this handbook doesn't cover everything. Of course it doesn't. We couldn't possibly cover every scenario that could arise in day-to-day work life. Instead, it just covers some big, broad rules and procedures that we can anticipate coming up frequently. If you have multi-state operations, and this I want to be broad, like sometimes multi-state operation is like, we employ one guy who works out of his home in Oklahoma. Well, you're a multi-state operation now, because that one guy who works in Oklahoma, he's subject to Oklahoma state employment laws, not Texas employment laws. So ideally, if you have a critical enough mass size in different states, you'll have different handbooks that are state specific, and they will address the differences. Like, for example, Louisiana, you have to pay out an employee their vacation bank when you terminate them. It's not optional. And so you'd want the handbook to say, we're going to pay you out your vacation when you separate. But even if you don't have a state specific handbook, I recommend the intro says, our headquarters are in Texas. This handbook typically applies to people working within the state of Texas. And to the extent you might work in some other state, well, then if there's any conflict between anything said in this handbook and that state's law or the local law of that region, well, that law and that state applies, not whatever is said in this handbook. Because we always say that the law trumps the handbook. If there's any conflict between the handbook and the law, we follow the law. And that's our intent as an employer, to follow the law. Similarly, I like a statement that says, if there's any conflict between any kind of benefit plan documents, like the health plan or the 401k plan or the disability insurance plan, if there's any conflict between what's said about that and in this handbook and the actual plan documents, the plan documents govern. They control, not this handbook. We want to say something usually about the handbook itself is a confidential company document. It's the property of the company, and it should be returned. In your exit interviews, you should be asking the employees to turn back their company handbook if they took a copy home. You should be saying in your intro that we encourage people to ask questions because we haven't covered everything. Please ask questions and to whom you direct those questions to. And then the acknowledgement form will typically repeat many of these same points that are critical to the introduction. So then besides the introduction, probably the most important document or policy is your equal employment opportunity policies, your harassment, discrimination, retaliation policies. I want to say a pitch for, I like them at the beginning of the handbook. I know sometimes people will organize their handbook almost like chronologically, like their onboarding policies, and then they get towards the middle of the policy, the handbook, is things like rules of conduct, and they'll put these EEO policies around rules of conduct. Well, it's better to be able to testify, if you've got a 40-page handbook, you gave it to somebody, they acknowledge receipt of having had it, they acknowledge that they were supposed to read it and follow it, but then they ask and they say, oh, I didn't read it, it was too long. And I didn't bother to look for that harassment policy. Well, if it's on page 4, it's a lot more compelling testimony to go like, you didn't make it to page 4 instead of I didn't make it to page 20. And so I advocate moving these up to the advance, the beginning of the handbook, right after the introduction, even if it doesn't make sense. If you put things more topically, it's okay to just pull these out, and they get special treatment because they're so important. And with the expansion of Texas sexual harassment law, of course, every employer should have one of these policies. As I mentioned earlier, the complaint procedure needs to have at least 2 alternative avenues for people to complain in. 2, and you do not want to limit this policy to sexual harassment. This is such a common mistake. They'll do the equal employment opportunity policy, like we're an equal employment opportunity employer. We do not discriminate in the terms and conditions of employment, like hiring decisions, training, promotion, discipline, demotion, discharge, etc., on the basis of race, religion, and they list everything out. And you go, oh, beautiful, that's so great. And then the very next policy statement is our policy against sexual harassment. And it just talks about sexual harassment. Well, the law is racial harassment is against the law. Religious-based harassment is against the law. Harassment based on somebody's disability is against the law. So you want to make sure that your harassment policy is worded to cover all of the various forms of unlawful harassment. And those forms are race, color, national origin, ethnicity, religion, age of over 40, sex, pregnancy, childbirth, and related medical conditions, sexual orientation, gender identity, physical disability, mental disability, genetic predisposition, like you have a genetic predisposition to certain diseases, maybe like you have the breast cancer gene, for example, veteran status, citizenship status, and then always, even if you forgot some of these other bullets, or there's some other bullets that I've forgotten that aren't out here, you always want that catch-all or any other basis prohibited by applicable federal, state, or local law. So you always want to include that catch-all. I've, in recent years, found employers do a better job at mentioning the duty to provide reasonable accommodations under the ADA. For several years, I'd always have to write it in. I'd get a handbook and be like, oh, I got to add that. But now I'm finding employers are more attuned to their EEO policy should include some statement as well that the company will also make reasonable accommodations for disabled applicants and employees in accordance with any applicable law. So besides the duty not to discriminate under the ADA, the Americans with Disabilities Act, there's this duty to provide accommodations or reasonable accommodations. And so there should be a reference to that in your handbook somewhere. And then a really quick slide. I know this was mentioned when the STIBS lawyers did their presentation 2 weeks ago on COVID issues, but long COVID is now being seen as something that can qualify as a disability under the ADA. So that means somebody is suffering chronic fatigue, months after they've recovered from COVID. They're no longer testing positive. They've been back to work for months, but yet they have these lingering symptoms that are kind of a mystery for our medical condition or our medical community, like headaches, fatigue, chronic coughs, etc. And if you've got now in the HR world an employee who is suffering from fatigue and they tested positive for COVID within the last couple of years, you're going to have to think, is this an instance where I need to engage in that interactive process to see if they need a reasonable accommodation, because they may qualify as disabled under the Americans with Disabilities Act. I also wrote a blog article on this topic if you wanted to read more. Finally, this is a policy that I think is probably one of the most important policies as well, and it should be in practically 100% of handbooks. And I would say that I find it in about 5% of the handbooks. So less than 10%, I would say, of when I get a handbook and I'm looking for this policy because it's got to be there, it's most of the time not there. And what is this policy? The FLSA is the Federal Fair Labor Standards Act, which governs minimum wage and overtime requirements. And we could all do an hour or more presentation just on the FLSA alone. And many of us in the audience have probably attended those, where they talk about classifying somebody as exempt or non-exempt from the overtime pay requirements. We all know from those presentations that paying somebody a salary is not good enough. That does not in and of itself make somebody exempt from the salary or overtime requirements. But to be exempt from the overtime requirements, typically you do have to be paid on a salaried basis. Not always, but typically you do have to be paid on a salaried basis. So what's the problem? What is this FLSA safe harbor policy? Well, the Department of Labor has issued what these things called fact sheets. It's FACT. And the Department of Labor, in these fact sheets, which they probably have 20, 30, 40 of them, they're wonderful. They're 2 or 3 pages long. And this is a very complicated statute. It's been around for close to 100 years. It was part of the Roosevelt's New Deal legislation. And these little fact sheets are designed for employers, not lawyers, to understand the statutory requirements. And if you just Google DOL Fact Sheet, you're going to come up with all the list of all of these different fact sheets, and it's going to help you understand the Fair Labor Standards Act better. And so if you're ever having to do with like a minimum wage or overtime requirement issue, I highly recommend just Googling DOL Fact Sheet and checking out some of this reading, because it's only 2 or 3 pages per topic, and it can really help a person understand the complicated nature of the statute. Well, there's this one fact sheet called Fact Sheet 17G, because besides the numbers, some of them have like A, B, C, D, but this is all about how you properly pay somebody on a salary basis. And in it, if we zoom in, it talks about if you make deductions from salary, you can kill somebody's overtime exemption. So like I'm exempt from overtime pay requirements as a salaried lawyer, but if my employer starts making some improper deductions, well, I could be entitled to overtime pay for the last 3 years for any hours I worked over 40 in a given work week. That's an expensive lawsuit to defend against. But let's look at the very bottom. You see this thing called safe harbor. See that? Now, if we zoom in on this, it says safe harbor. If an employer, one, has a clearly communicated policy. And as a lawyer, whenever I see clearly communicated policy, I go ding, 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 ding. That belongs in a handbook. Right? What better place to put a clearly communicated policy on a personnel matter than in your employee handbook? And it says, if you have this policy that says we prohibit these types of improper deductions, and we're going to have a complaint mechanism, just like we have the ways you can complain about harassment. Well, here's a way to complain about pay deductions that you think were improper. And hey, if we find out we made some rogue maverick sort of deduction, we're going to pay you back. We're going to give you that money back. We're going to reimburse you. And it makes good, you make good on that commitment, well, then you don't kill the overtime exempt status by virtue of those improper deductions. So every employee handbook should have one of these FLSA safe harbor policies. Another common mistake related to FLSA is omitting a break time for nursing mothers policy. That, if you look at DOL fact sheet number 73, will give you some more information on that. Another big common mistake on FLSA is to say, if you work unapproved overtime, you will not get paid for that unapproved overtime. That is going to invite a lawsuit because you have to pay for it. The law is if the person was suffered or permitted to work the overtime. So permitted means they got the authorization. Suffered it meant they just worked it. They might not have gotten the pre-authorization to do it, but they did it. They worked that 45 hours this week. The law says you have to pay them. Now, the law says too, though, you can discipline that employee. So you could have in your policy statement something that says, and I recommend that it says something along these lines, that if you work unapproved overtime, you will be paid for that unapproved overtime, but you might be disciplined up to and including potential termination of your employment for having just worked some extra time when nobody gave you permission to do that. Finally, our Family Medical Leave Act. This is kind of the Goldilocks rule. I'm going to talk about how I see when employers include too much information, and then I see where employers include not enough information when it comes to the FMLA. Where it comes into play when they do not too much is when they are an employer that has under 50 employees. If you have under 50 employees, you're not covered by the FMLA. So your handbook should not have anything to say about the FMLA. And if you have one of these posters, these collages, you should take a piece of white paper and tape over the poster that has to do with FMLA. Because there's even some case law that says that an employer could be what's called a stopped, like equitably stopped from arguing, I'm not covered by that statute. If you've been advertising to your workforce, oh no, we allow for medical leave and we allow for family care leave. And so if you're a small employer, take it out. Now, if you're a big employer and you're covered by the FMLA, I highly recommend that your policy statement talks about the various wage and hour law forms that have been issued for administering this. Because I can tell you so many companies make a mistake and don't use these forms, and then they never even designated the FEMLA leave clock as starting. Like somebody went out on COVID and it's 3 months later and they're still not back to work. And you're thinking they've exhausted their FEMLA leave. But did you ever give them the form that tells them you're designating the time off as being time off under FMLA? Did you give them form WH-382 or some equivalent document? If you didn't, the clock never started ticking. And so I always advocate, if you just Google FMLA forms, you're going to find all of these forms on the Department of Labor's website, and you should reference them in your handbook. And that's so that everybody in the organization is familiar with, if we get an FMLA request, we're going to utilize these forms. And particularly, as I mentioned, with like people going out on COVID leave, which could qualify as FMLA time, you're going to want to make sure, you know, employers are like, of course, stay home. We don't want you to bring an infectious disease into the workforce. So people are very quick to say, yeah, you've got that time off. They don't really ask for the certification from a healthcare provider, or they don't do some of the other forms, but you need to make sure you at least did that designation notice to say that we're treating this as FEMLA, as well as you should do the first form, the WH-381, that gives the employee the notice of their eligibility for FMLA time off and what their rights and responsibilities are during the leave time. Before we go to questions, I know we're almost done with our time. I always like to give, when I give these presentations, an advertisement for the Texas Workforce Commission's book, because I think it is a wonderful resource for HR managers and business owners. If you were just to Google, especially for Texas employers, so just those 3 words, especially for Texas employers, or TWC, Guide for Employers, you're going to get this book. I've got a hard copy here. Maybe it's not showing because, I have to put it in front of my face. Well, it's not showing anyways because my filter, but this is, I've got a hard copy here. If you go and you Google it, you'll see, and I'm going to scroll here. There's 3 different ways that you can access it. You can access it online, and that's lovely because you can even cut and paste online sometimes to like a sample policy, like cut right into your Word document to, because I always figure if the government suggested you word a policy this way, well, then I'm going to follow what the government said, because it would be hard pressed to criticize me later in a lawsuit that I worded it that way if the government suggested I word it that way. Another way that you can access it is there's a PDF. So if you wanted to just click on it and download it so that you had it on your desktop for ease of reference instead of always having to go to the online version. And then the third bullet point, they say that they'll even give you a print version if you request it via email. The copy I got, I went to one of the TWC's offices where they administer unemployment benefit rights for employees, and I got a copy several years ago because I keep it on my bookshelf and I refer to it from time to time. And why do I think it's so great? Here's the table of contents. There are wonderful chapters on all kinds of hiring issues, pay and policy issues, work separation issues, post-employment issues. So any type, like for example, last week's speaker talked about unemployment insurance benefit claims. Well, there's a whole chapter, several subparts by the agency that is the agency that oversees unemployment insurance benefit claims. So what a wonderful tool to be able to read what they have to say in terms of best practices for dealing with employment applications as an employer. And then finally, if you look at these later parts of the book, they have sample personnel policies. Now, unfortunately, they don't have like an A to Z, even though they say the A to Z of personnel policies, they don't have like a complete sample employment handbook that people can just cut and paste and utilize. But they do have a lot of sample policies in there, including some wage deduction authorization agreements and some other types of agreements separate from the handbook. They have this subchapter on posters, employer posters. So an excellent resource for employers to have a handy, free HR manual issued by the government. And so I will turn it over to questions with that as my final pitch.
April, thank you so much for the valuable information. Great tips and things that people may not have known about. We do want to end with Q&A on some of these topics. So we'll start with some questions that were submitted in advance. And then if anybody would like to ask a question of April, you can put that in your Q&A box at the bottom of your screen, and we'll try to get to those as quickly as we can. One of the questions is, if you have a non-compete in place, when the law changes, does it affect the contracts that are already in place, kind of like grandfathered in, or will all of that be just scratch and start fresh?
We don't know, but as you mentioned, there's a possibility for a grandfather clause. So now's the time to adopt them if you want them in place, because certainly when the law takes effect, they aren't going to give a grace period, like everyone go lock in your non-competes with your workforce. They're only going to allow, if they even allow this, the grandfathering in. And so now would be the time to get those in place.
Good advice. What do you think is one of the most overlooked and important handbook policy item? If it's something that you hadn't covered, maybe.
Yes, sure. I didn't have time to bring this up. I just briefly mentioned it, but I think vacation policies are key. And that's because there is very limited law when it comes to vacation policies. Instead, it's really up to the employer. What do they want to provide? Now, there can be some, as I mentioned, state laws that say that the bank must be paid out upon termination. Like I gave the example of Louisiana. California is another example where if you've got it in the bank, you get it when you get terminated. But Texas isn't one of those. Texas is, you could as an employer say, we're not going to pay out the bank when you terminate. But you just need to say, what are the rules? How does it accrue? Is there any rollover from year to year? Or does it, like, the bank go back to zero come January 1? Are there any caps on accrual? Like, sure, we'll pay it out upon termination, but you can't, be here for 15 years and never use your bank, and then we owe you hundreds and hundreds and hundreds of hours of vacation when you leave. Instead, we're going to say, if you, accrue up to 100 hours, you're not going to accrue anymore until you use some. And that encourages people to take time off because we don't want people to be burned out. There also needs to be something about the procedure for asking for vacation. What happens with holidays that happen while the vacation time is being taken? Does that count as a vacation day too, or do we just count that as a holiday? So there's all these different things that need to be covered, and they are what the employer decides they want the rule to be, but it's best to articulate it. And that way everyone is uniform and consistent, and then you're not open to discrimination charges where sometimes you paid out to these employees when they left, but other employees, you didn't pay them out. And if those other employees who didn't get paid out happen to be a member of a legally protected class, they can sue you for discrimination. Like, why didn't I get it when all these other people who are not in the protected class got it?
Very good. Great information. And then do we need to include any special language in our handbooks regarding COVID? You kind of touched on it a little bit, but if you have anything else to add.
I think it remains to be seen. If you have a vaccine mandate, probably, I've written a lot of standalone policies right now, but most employers aren't integrating things into their handbooks yet because the law keeps changing and we're just all kind of racing to keep up with what is the law related to COVID. But I can envision there at some point being a need to put something like we require our workers to be vaccinated, and it's a condition of employment. Now, certainly you're going to want something about COVID if you require vaccines in your job postings, like when you're advertising an open position. If you have a vaccine mandate, you should be putting in your advertisement, we have a vaccine mandate. And then in your offer letter, your offer should be contingent on them showing proof of vaccination before their start date. So there are places that we're seeing COVID related policies pop up. I'm just not seeing it so much in the handbook yet.
Okay. Gotcha. Well, I'm going to kick it over to Mariana since we don't have any other further questions.
Yes. Thank you so much to everyone for your time today. And we do have April's information up here on the screen. Since we didn't get any today, I'm sure there probably are some burning questions out there. Feel free to reach out to her directly. We'll also be sharing that when we share a recording of the webinar, so in case something comes up in the future. So thank you.
Well, thank you to everyone, and especially to our partners at Kean Miller. April, thank you for your time today. The EDP is proud to host meetings like this throughout the year. If your organization is not already a member of EDP and you're interested in becoming a partner, feel free to reach out to us in our office for details. And we thank you so much. Take care.
Bye, everyone.